applies its rules. One of its rules says that it cannot consider complaints about credit risk decisions. It's actually excluded from its jurisdiction. What they can consider is what they call maladministration. Well, they can, at the moment, can also consider responsible lending, but outside responsible lending, so like the small businesses example I talked before, maladministration. And that's whether the lender had systems and policies in place and did they follow with them. What they can't do is make any sort of determination based on the quality of that decision, because that'll be outside jurisdiction. So while consumers will be able to complain to AFCA's ability to resolve those disputes will be really limited, and because it'll have to apply the law at the time. And so we expect that consumers will not get a remedy through complaints to AFCA.
Look, just finally, you heard the witness, you were in the room, I think, Mr. Brody, beforehand for the witnesses from some of the industry organisations talking about the flow of credit in recent years, and I know that your submission goes to that as well. APRA's view is that the constraints on credit are not associated with the regulatory burden. Do you, that view was contested by our previous witnesses. Do you have a view about the availability of credit and the relationship with the regulatory structures?
Well, I can only observe the data that is put out by the likes of ABS and also the statements of experts like Treasury and even international institutions. I mean, the data shows that owner-occupier home lending is at record levels. And the highest levels since records began in 2002. Even credit card lending has gone up in the last couple of months. So there does seem to be credit quite freely available in the economy. In terms of, I guess, at that macroeconomic level, the Royal Commission again, quoted Treasury in saying that, that there was no evidence that responsible lending laws materially affected the availability of credit, and in fact they contributed to the macroprudential soundness of the economy. And we also quote in our submissions some of the things that have been said by the OECD and the IMF. The OECD talks about risks to an economy where there is high household debt. Australia has the second highest household debt in the world. And they say that marginal expansion in private credit is associated with lower long-term growth and rising inequality in advanced economies where credit provision is already high. And the IMF found that the experience of the global financial crisis suggests that high household debt can be a source of financial vulnerability and lead to prolonged recessions.
Actually, there is just one more follow-up. Sorry,
quickly,
Senator Brooklyn, but you're indicating in your earlier evidence that AFCA presently relies on the actual responsible lending provisions as part of its framework. What will AFCA be able to rely upon if they're removed? On what basis will they decide matters?
Well, I guess that's really unclear at this stage. I mean, one of them would be, so the banking code of practice may be applicable to banks. Now, at the moment, for small business lending, it says there must be a prudent and diligent banker. That's the test. And that goes to, as I said, the systems, not the individual borrower decision. For consumer lending, at the moment, the banking code of practice says that banks must comply with the law, so the responsible lending law. So when that's removed, it's quite unclear what will happen in terms of the banking code of practice and what it will govern in terms of consumer lending. Look, there are other rules in place, like the general rule of fairness, but that hasn't been very effective in providing some accountability and remedies on institutions and remedies for consumers in behalf. So, for example, there has been case law around unconscionable conduct and lending or unjustness and lending. And it's been very difficult for consumers to prove that in each specific case, particularly in instances where lending is intermediated. So it's through a broker, for example. So it may be that the broker knew something was awry, but the lender can just turn a blind eye to that, and the borrower has to repay the full amount.
So a radical intervention into that AFCA jurisdiction. Thank you.
I will need to move to Senator Bragg.
Thanks, Chair. Thank you very much for making your time available. I'm trying to just ascertain your position on the regulatory framework, which is quite extensive in this country. So firstly, are you aware of APS 220?
I am.
Okay. And are you aware that it contains extensive obligations for ADIs to, quote, assess the strength of a borrower's repayment capacity?
I am.
Okay. And you're also aware that it contains an obligation on the ADI to assess the current risk profile of the borrower, including making reasonable inquiries and taking reasonable steps to verify commitments and total indebtedness?
I am.
You are, okay. And there's various other components in that. Are you aware that that is a standard that will be applied to non-ADIs?
Reading the draft non-IDI standard that Treasury has released, there are some of the things picked up. It's unclear to me whether it's consistent.
Okay. And are you aware about the commitment to establish a substantial hardship test?
I am.
So, and then you're aware of the, as you said in your opening statement, the design and distribution obligations. You're aware of the intervention power, and you're aware of the existence of AFCA,
yes.
Obviously. Okay. So there is quite an extensive framework in place, is there not?
There is a consumer protection and regulatory regime in place, yes.
Yeah, okay. And so, but I mean, these tests in this prudential standard, they're quite specific tests. I mean, these are things that have to be done by ADIs and certainly by non-ADIs, collectively and individually.
Well, the ADI prudential standard does not give an individual a legal right to seek, for example, compensation if that test is not if that test is breached. So there is a removal of individual legal rights for compensation around lending decisions in this framework. I mean, it's unclear to me how or if AFCA will apply that standard. They've never applied prudential standards in their complaint handling before, as far as I know it. So that's quite unknown. The other thing about APRA, Senator Bragg, as I mentioned, its focus is as a prudential regulator. It's there to protect deposit holders' monies. It's there to protect financial risk in the system. It's not there to protect, to enforce consumer protection.
Well, that's what AFCA is there to do. I mean, AFCA is there to deal with complaints, but I mean, it's just not true to say that that responsible lending is going to be repealed. I mean, that principle of responsible lending is embedded in this prudential standard. I mean, it's as if, I mean, I'm sure you're, doing your best to be pure of heart here, but I mean, the reality is that these are real tests that exist in Australian law, right? So an ADI must assess credit risk primarily on the strength of a borrower's repayment capacity. The current risk profile of the borrower must be assessed, including making reasonable inquiries and taking reasonable steps to verify commitments and total indebtedness. I mean, these things exist.
Well, I would point to, I guess, again, what Commissioner Haynes said about the existence of standards in law and in regulatory arrangements, including codes, that they've got to have effective compliance and enforcement regimes to ensure that they're met. And so that's what's being, I think, removed
But what
here.
do you think these things are?
I think that there's no compliance regime around that individual test in the standard. APRA is not going to undertake thematic reviews around whether at an individual level there is compliance with that standard.
But hang on. You can't be seriously saying that the way this prudential standard is designed to work, that APRA can just ignore individual loan applications. Like, they have to look at the whole picture. When the institution is the way that this, for this to work in the way you said it would mean that every ADI is basically breaking the law every time. I mean, that when a borrower comes in to extend credit or something, I mean, they have to look at the whole picture.
Well, I guess the APRA and the ADIs, that applies to ADIs. Obviously, there's a different framework for non-ADIs. I guess in relation to APRA, and it did release a consultation paper earlier this year to add this additional line about making sure repayments were affordable for the individual.
Yes.
And they said in their consultation paper that this amendment is consistent with its current requirements and that it does not oppose any additional burdens. So no change is going to result. So I read from that, APRA has not done individual consumer protection in the past. There is no change that they will do that in the future. So that is going to be removed from the regulatory framework.
So what about section 47 of the NCCP? So what do you think that's all about?
You're talking about the general licensing conditions about fair, efficient and honest?
Yeah, general conduct obligations. So what do you think that means?
Well, I think that, again, it's probably uncertain exactly what that means. There has been limited court jurisprudence on the meaning of that phrase. And when it's applied to lending, I can point to, for example, the court decisions that relate to unconscionable lending or unjust lending, which are fairness and unjustness have a same sort of jurisprudence around them. And as I was explaining to Senator McAllister, the court jurisprudence shows that it's very high bar to show that there's breaches of those legislation. And the example I would give would be around intermediated lending, where a broker is involved, even if the broker is aware of the borrower's situation, that they can't afford repayments, that is not very easily brought back home to the lender under those arrangements.
So I guess the question is, though, if you think APRA is as bad as you say it is,
I don't think
banks are as reckless as you suggest. I mean, why hasn't there been more widespread failure?
I don't suggest APRA is bad. I think APRA is a world-class regulator.
Right.
Its role, though, is not individual consumer protection, is my point. Its role is
Senator
to
Bragg, could I just add something?
Please.
Yeah, go ahead.
No, it's just really, I just want to try and bring into the room the clients of financial counsellors, and I'm sure APRA does a good job in making sure that banks don't fail and depositors are protected. But we see lots of people who are given debts that they really struggle to repay. So this is a current problem. It's got better after the Royal Commission, but it's been an ongoing problem. So it's not working. It hasn't been working.
Okay, so what proportion of people are in this position?
Oh, thousands of people.
Thousands, okay. And how many loans are there in Australia each year?
Is your argument that...
Well, I'm just trying to work out what proportion of the community we're talking about here. And we're talking about this happening within a very important regulatory framework at a time where clearly the economy needs more credit, and there is an extensive consumer protection scheme in place which is going to be strengthened. So you're saying this bill is going to cause all these problems. I'm just trying to understand what exactly are your metrics behind that.
Well, I think
there's some current problems with debt.
I think I would add, I mean, there was some data, again, in the Royal Commission report that showed over the first sort of 8 years of responsible lending, there was, I think, 500,000 customers that received compensation for breach of lending standards in relation to home loan lending alone. So it did affect a large proportion of people. And I would also say that banks... I think that they learn a lot from the Royal Commission, and we work very closely with the banks and have a cooperative and collaborative relationship with them. And I speak to the CEOs of banks, and they're concerned about every customer. They want to make sure every customer is treated well. And so that they, just because it harms a small proportion, I don't think that's the way we should set up a regulatory framework. We should have a framework that ensures that everyone is protected.
Mr. Brody, look, I respect that you're trying to do good work here and represent...
This is a legislation inquiry into, government legislation. People are invited to make submissions. The submissions are assessed. The committee invites people to give evidence. I'm bemused by the fact that it appears to be being used by Senator Bragg as a you're wrong, I'm right situation, rather than a simple test of evidence given, submissions before the committee and testing the relevance of that submission. I'm not sure right, wrong or whatever comes into it.
Well, I think that Senator Gallagher, we provide a reasonable amount of latitude as long as you are on topic in this committee, as you know, and Senator Bragg has every right to challenge the assumptions that underlie witnesses' submissions to this committee. His line of questioning is certainly in order. Senator Bragg, you will need to finish up though, because I will need to share the call.
Thank you, Chair.
I just wonder, it might make it a little more courteous for the witness if Senator Bragg did refrain from speculating about whether or not Mr Brody is or isn't acting in good faith. I think that would be something we might reasonably ask of him.
I will bring that to Senator Bragg's attention. Senator Bragg, you have the call.
Well, the position is that you are saying this bill should not be passed by this Parliament. And
You have the numbers.
you are saying that the bill should not be passed by this Parliament. And I'm simply saying to you that there is an extensive set of regulatory tools on the table. There is the distribution and design obligation, there's the intervention power, there's unfair contract terms, and then in terms of this specific issue that you've raised today about the bill and whether or not vulnerable people would be given credit when they shouldn't be, which I think is effectively your concern, and it's a valid concern, right? It's a concern that we all share. I'm just putting to you that the obligation in this prudential standard is very clear. It applies to an institution when they're making 1 loan, 2 loans or 5 loans to an individual. I mean, that is the only way you can read this standard.
Yeah, and
I just don't understand why.
Well,
can I try and explain it for you?
Answer, and that will need to be the last question for now.
So my response to that is there is a standard, but a standard is not sufficient without an adequate compliance and enforcement arrangement behind it. There is no individual right to challenge a bank at court around the prudential standard. There is no regulator that has, APRA can't take a bank to court and seek a penalty for a breach of the prudential standard. The culture of the regulator, its approach as a regulator when it comes to consumer protection is entirely different than a prudential regulator. And I think that even people from APRA would agree that that's not their role. They're not going to be concerned about taking regulatory response in relation to individual breaches.